Ladies and gentlemen, welcome to the National Constitution Center. Here towering over you, I am Jeffrey Rosen, the president of this wonderful institution. The National Constitution Center, as some of you know, and let's recite this in unison for the senator who's just been enjoying our incredible exhibits downstairs. The National Constitution Center is the only institution in America chartered by Congress to disseminate information about the U.S. Constitution on a nonpartisan basis. You see, we have this great members and friends who are so inspired by our congressional mission. And I'm about to introduce what is, I think, going to be one of the highlights of our town hall season. But before I do that, I have to just give a plug for the incredible events that are coming up in the next couple of weeks. On Monday, April 13th, Thomas Jefferson's birthday, we celebrate Freedom Day, which is a national celebration of freedom, bringing together the leaders of the top think tanks in America, the Aspen Institute, the American Enterprise Institute, Cato, the Center for American Progress, and the ACLU, all converging to discuss what the conservatives and liberals and libertarians agree and disagree about the future of freedom. And panels about the future of free speech and religious liberty, stand-up comedy by Grover Norquist. It is going to be an amazing celebration of freedom, and I hope you will all join us. Monday, April 13th. It's going to be great. All day, starting at 3. Next month, we launch the second in our series of national town hall debates, co-sponsored by the Federalist Society and the American Constitution Society. We launched 2 weeks ago in Washington, D.C. with a phenomenal debate about the Hobby Lobby decision in Boston. We're going to talk about whether the Citizens United case was rightly decided. And we believe that this incredible collaboration of these two great organizations will transform constitutional discourse, just like the Lincoln-Douglas debates did. And it's really exciting to be able to co-sponsor these nonpartisan debates. And then there's just our usual phenomenal series of book interviews on you think Monday is good enough. On Tuesday, we have scholars from around the country for a series of great discussions about the relationship between the Declaration of Independence and the Constitution, and then we're off and running for the rest of the spring. So now it is my great pleasure to introduce two esteemed guests. And first, I'm going to introduce our moderator, who is so important to the National Constitution Center for this reason. Daniel Austin Green is Director of Individual Freedoms and Free Markets at the John Templeton Foundation. It was because of Daniel's vision and his commitment to liberty and the Constitution and bringing groups together that the National Constitution Center was able to get an extraordinarily generous $5.5 million grant, which makes possible all of these town hall debates and discussions and the great interactive Constitution that we are building together. So a round of applause for Daniel and for the Templeton Foundation. Before joining the foundation, he was resident scholar and fellow at the Liberty Fund. He is a graduate of Cardozo School of Law, and we bonded over this immediately. He's a gifted tenor who studied vocal performance at Juilliard. So welcome to Daniel. And now, ladies and gentlemen, it is an honor to introduce the 16th senator from Utah, Senator Mike Lee. There are few senators in American history who've been so devoted to the Constitution that they have focused the attention of the nation on its text and history and have performed such an invaluable service in promoting constitutional debate. And if you believe that senators take an oath of office to uphold the Constitution and have a duty independently to interpret it, you must be grateful to Senator Lee for his commitment to constitutional education and debate. His constitutional pedigree is impressive. His father, Rex Lee, was one of the storied Solicitor Generals of all time, Solicitor General for Ronald Reagan, widely respected for his fair-mindedness by both sides. And from an early age, Senator Lee was exposed to the text and principles of our Constitution. He graduated from Brigham Young University Law School and was a law clerk to Judge D. Benson, and then to future Supreme Court Justice Samuel Alito, who honored us by opening our Bill of Rights exhibit and is our circuit justice and has been such a great friend of the Constitution Center. And Senator Lee went on to clerk for Justice Alito on the Supreme Court as well. Are you the only senator who's a Supreme Court law clerk?
I was the first who became one. There are now three. Richard Blumenthal, Ted Cruz, and myself.
Impressive. Great. I'd love to hear those discussions in the Senate dining room. His incredible legal career included years in private practice. He was an assistant U.S. attorney, also general counsel to former Utah governor and Pennsylvania great citizen John Huntsman. He now serves on the Judiciary Committee, chairs the Antitrust Competition Policy and Consumer Rights Subcommittee, where he promotes economic liberty. And I just have to say, it's always an honor to welcome a U.S. Senator. It's a special privilege to be able to tease out their views about the Constitution, but I do not think we have had the honor before at the Constitution Center of a senator who's in fact written an entire book on his constitutional philosophy. I can't imagine a better interviewer or interview subject than Senator Mike Lee. Welcome, Senator.
Thanks, Jeff. So when the NCC got in touch and asked if I would do this, later I quipped to a friend, I'm really skeptical about reading a book by someone named Senator. But the beauty of this is that it's not a political book. It really is a constitutional book. You really care about the structure of the Constitution, and in a way that I think anyone, Democrat, Republican, Libertarian, left, right, up, down, whatever, should care about these issues. And it was really impressive to read the book because you definitely have the constitutional, legal, and historical bona fides to really tackle these issues. But you do it in such a clear and articulate way that you don't have to be a constitutional lawyer to understand these things. So one of the things I think is central to the book really starts getting going in chapter 3. Well, first you open up with the vignette that you have 2 stacks of paper in your office. All of the legislation Congress passed one year, and that's a few inches, about 800 pages, and then 11 feet, 80,000 pages of the agency regulations promulgated in a year. And in chapter 3, you really detail the administrative state and what's happened. And you really kind of indict your institution, right? You really call Congress to account for delegating their own responsibilities. And as we discussed, I first became aware of this when I was in law school and working with a professor who does administrative law. And I realized, how much is happening in the agencies. But I think, even people that I've talked to over the years who I think would be informed about these issues aren't. They don't realize. So could you just introduce us to the kind of the scale and scope of this problem of Congress delegating its authority, really, to the agencies?
Sure. And thank you for that nice introduction, by the way, and thank you for letting me join you here this evening. As we were touring the Hall of the Signers earlier, and as we were walking through some of the other exhibits where they show you where you can compare and contrast different provisions of the U.S. Constitution against their counterparts in constitutions around the world. My wife, Sharon, who's here with me tonight, along with my daughter, Eliza, my wife said to me, noticing that I was reluctant to leave this hall, looked at me and she said, Mike, you can't live here. This feels like Disneyland to me. Anyway, this is one of my favorite parts of the book that you refer to, Chapter 3. Chapter 3 talks about what I perceive to be a constitutional problem of our time. We have a Congress which in a really bipartisan way has completely abdicated its lawmaking role. These 2 stacks of documents, one 11 feet tall, one just a few inches tall, represents that most of the law to which the American people are subject is no longer passed by men and women of our own choosing. They're written by executive branch bureaucrats. Great men and women, hardworking, well-educated, specialized, and well-intentioned. But they're not subject to elections. And this is a problem. I introduced this in Chapter 3 by telling the story of how Alexander Hamilton at the Constitutional Convention actually proposed a monarchy. And this, of course, was met with a lot of skepticism. It went over like a lead balloon just a few blocks from here. By the way, I'm still awestruck at the fantastic view that you have from here of Independence Hall. It didn't go over well, and with good reason. The Founding Fathers were very concerned about the risks that would accompany the excessive accumulation of power in the hands of the few, or especially in the hands of one person. So that's why they went out of their way to divide up the power. And I think they would have been surprised to see how much de facto lawmaking power is now vested within the executive branch of government. When I was in law school about 20 years ago, we had a guest speaker who came and talked to us about the risks of the federal regulatory state, the fact that it was costing the American economy $300 billion a year to comply with this. He said this is a backdoor tax, it's an invisible tax. People don't realize it, but it's a cost of government. And a lot of people think that regulatory compliance costs are just borne by the wealthy or by big corporations. They're not. They're passed downstream. They're passed down to end consumers, poor and middle class Americans who end up paying higher prices on everything they buy as a result of these regulations. But these are put in place not by elected officials who stand accountable, but by people who are insulated from the political process, and that has real risks. It's also really contrary to the Constitution.
So, as political actors, it makes perfect sense why Congress wants to do this, right? You create the organic statute, the XYZ Act, and then that creates the XYZ agency, and if they're a success, Congress gets all the credit, and if it's a disaster, Congress says, hey, you know, we did the right thing, they're the ones who screwed it up. But is there another motivation? Is there something, I mean, are your colleagues trying to pull a fast one on the American public? Is this just something that over the decades has crept up and gotten out of control? What are the kind of internal mechanisms or motivations that go on within Congress?
Okay, let me undercut my own argument by making the best argument that I can for the administrative state. The best argument I can make for it is the legislative process is difficult, it's time-consuming, and you want to get to yes. You want to get legislation passed, especially where you're trying to do something really good, like, say, you know, clean up the air or clean up the water or protect us from this or that threat. And so sometimes you start with broad principles and you can achieve a lot of agreement there. So there are some good motivations behind this, even though at the end of the day, I think what perpetuates it most, even if it's only at a subconscious level, is what you describe. You can get all the credit and none of the blame if you vote for broad aspirational legislation. For example, imagine a hypothetical bill that said we shall have good law. And we hereby delegate to the herewith created Commission for the Creation of Good Laws the power to make good law. And that commission will make good laws and then will then carry out, execute, and enforce said good laws. We can all see the problem inherent in that because you've completely punted the legislative power. There's no point in having elections anymore. The elections are a sham. There's nobody really at the end of this stick who stands accountable for it. So if that disturbs you, consider the fact that that is exactly what we've done. The only difference is that we've sliced that up into lots of smaller delegations that we have sent out to these alphabet soup agencies around the country. And again, these agencies run by good people, good American citizens who love their country and want to serve it well. But it's not what the Constitution contemplates. It's not what the Constitution requires. And I think it naturally, inevitably undermines the system of political accountability that was built into the Constitution.
Another theme throughout the book is the separation of powers. And the intersection it has with the administrative state is that each of the three branches have different and independent duties to check and balance each other. But part of how they do that is by having independent duties to safeguard the Constitution. Why has the court been so deferential? You know, I mean, there's essentially no non-delegation doctrine anymore. And why has the court caved in on this issue? Are they letting down their end of protecting the Constitution?
All right, the short answer to that question, the question at the end of that is yes. I do think the court has dropped the ball there. I think it is a mistake on the part of the court not to enforce a non-delegation doctrine. We have a non-delegation doctrine, it's just that it's a toothless tiger that frequently disappears. That's probably too many metaphors. Toothless tiger with an invisibility cloak borrowed from Harry Potter. So yeah, I think the court has dropped the ball there. But a recurring theme of my book is that not every constitutional problem can be blamed on the court entirely, and we can't always point back to the court as the source for solving the problem. We need sometimes to get to the root of the problem, and it's very frequently Congress itself that creates the problem. Yeah, separation of powers is critical to all of this. But I was raised in a home where we talked a lot about the Constitution. I didn't realize that was unusual at the time, but I think I was 30 before I realized not every family talks about the presentment clause over the dinner table. But my dad used to tell us that there are two structural protections in the Constitution that are as important as any other feature in it. One operates on the vertical axis and the other along the horizontal axis. The vertical representing federalism and the horizontal representing separation of powers within the federal government. I wrote this book in large measure because I believe we have really blurred and weakened both the vertical and the horizontal protections.
Another interest of yours, I think, that you talk about in the book is the origination clause. So any bill that has budgetary implications needs to be introduced by the House instead of the Senate. And you give a very nice history of how that came about. And if you could explain the significance at the time, but also you describe a much more recent incident that involved the origination clause.
Sure. So just a few blocks from here, there was, of course, this very lengthy, seemingly intractable debate between the small states and the large states. And they were really having a hard time coming to an agreement about what the new Constitution would look like. Both camps had their own idea about what was acceptable. And to make a long story short, of course, the one thing that saved the discussion, the convention, and ultimately what became the compromise that is now the U.S. Constitution, was this agreement that, okay, here's how we're going to solve the problem. We'll have two separate chambers. In one chamber, the states will be represented equally, and the other, they'll be represented according to population. That still wasn't enough. In order to sweeten the deal, they had to add to it, oh, and by the way, in order to raise taxes, you'll have to start that measure in the body where the states are represented according to population. It could never have made it out of convention. We never would have had a constitution that could have made it out of the convention without that compromise. It certainly would never have been ratified without that compromise. And yet, we've kind of allowed that to be gutted, at least to a pretty significant degree. It became a significant factor in the 2010 deliberation in Congress over the Patient Protection and Affordable Care Act. The legislation that became known as Obamacare, the Affordable Care Act, started in the House of Representatives. But the bill itself started as something completely different. It started as something completely unrelated to the health care law that this eventually became. It was passed in the House of Representatives. When it came over to the Senate, it was subject to a strip and replace amendment in the Senate. So all the provisions of the Patient Protection and Affordable Care Act that are now in law, including the provisions raising revenue, raising taxes, those were all added in the Senate, not in the House. And so had we been following this, this law would not have been passed, at least not in this format. It would not have happened. It wouldn't have worked. This is yet another example of where I think the Constitution needs to be observed by members of Congress. One of my greatest sources of frustration in Washington is the fact that too frequently when you raise a constitutional question, the very first and last question that a lot of members of Congress will ask is, what would the Supreme Court do with this? Will the court invalidate it? Will the court get involved at all? And if the answer to that question is no, then they'll take that as basically synonymous with an answer saying this is fully constitutional. There is a difference.
You also have a chapter on the Establishment Clause. And it has a pretty provocative title, The Supreme Court's Klansman. And you talk a lot about Hugo Black there, who really, I think your claim certainly is that he fundamentally changed our understanding of the Establishment Clause. Could you give us a little background about what the Establishment Clause meant when it was passed in the beginning of the Republic, and what sort of transition there was in the 20th century under Black?
Sure, sure. So the First Amendment provides, in pertinent part, the Establishment Clause says that Congress shall make no law respecting the establishment of religion. At the time of the founding generation, this was understood and intended by those who drafted it and those who ratified it as a provision that was saying we will not have a national church. There will not be a national church established by Congress. And it was understood at the time that the reason this was the case had everything to do with federalism. It had everything to do with the fact that they didn't want Congress stepping on the toes of the states and telling the states whether or not they were going to have an established religion at all, or if so, what that religion would be. So it was not a provision that was intended to apply to the states. In fact, by the plain language of the First Amendment, it was intended to restrict Congress. It was later deemed to have been incorporated against the states, and for the non-lawyers in the room, what that means basically is that by operation of the 14th Amendment, some of the protections in the Bill of Rights have been deemed applicable to the states, even though they weren't written in such a way originally as to bind the states. The Establishment Clause should never have been part of that incorporation, regardless of what you think about the incorporation doctrine generally, because this was intended, first, last, foremost, as a guarantee that the states would not have their rights interfered with by Congress with regard to whether or not to establish a religion. This does not mean that I think it would be a good idea for states to have an established religion. And in fact,
you say in the book, I think that you wouldn't want to live in a state.
Absolutely
so
not.
why do we care?
Well, we care because the courts have gotten involved through the Establishment Clause in all kinds of things. The federal courts have gotten involved in all kinds of things that are, frankly, none of the federal court's business. All kinds of things regarding everything from how schools spend money on their educational systems and whether and to what extent transportation or textbooks or other non-sectarian aid can be provided to a school that happens to teach some religious doctrine within that school, to the acceptability of uttering a prayer in a public arena. These are things that the federal courts ought not be able to wade into. These are decisions that ought to be made at a state and at a local level. So I think it's unfortunate that they've interpreted it this way. And yes, I do tell the story about Hugo Black, who was a member of the Ku Klux Klan. He was, as a member of the Ku Klux Klan, he was defiantly anti-Catholic. He was a bigot. And he made it his mission in life to do what he could to undermine the ability of Catholic schools to do what they were doing. And I think he was motivated by this in the decision that he wrote in Everson, which planted the seeds, basically, for our modern Establishment Clause jurisprudence.
Another thing that comes up a couple times in the book is cronyism. And the first time it comes up is actually in Chapter 3 about the administrative state. And you point out that one Mr. Sunkist happened to be appointed to the Naval Orange Administrative Commission. I suppose he probably did have some knowledge of the subject, but this led to increased prices for all of us who want to enjoy a naval orange. And then later in Chapter 9, you point out much more recently with the healthcare employer mandate, you say we're making hard-working men and women comply, but then as you describe it, President Obama threw a big bone to corporate America. And I think both of these illustrate very different ways in which the government is beholden or at least deeply sympathetic to corporate interests. And, you know, I think both Republicans and Democrats can be charged of this in many accounts. But do you think that this is a function of the changes and the evolution of the Constitution you describe in the book, or is this a separate problem?
I think they're two sides of the same coin. I think they are inextricably intertwined. We have to remember what it is that makes our country unique, economically and otherwise, and a lot of them are bound up with and the natural product of our Constitution. We're relatively unique among nations, not only in the world today, but in the history of the world, in the sense that this is a land of upward mobility. This is a land where you can be born into poverty, and where if you work hard and play by the rules, there's a very good chance that you can retire comfortably one day. Perhaps wealthy, but at least comfortably. That makes us pretty unique. That didn't come from nothing. That exists because, I believe, we have a government that is limited by a constitution that identifies the appropriate place of government and puts boundaries around the role of government to make sure that bad things can't happen. Free markets can thrive where the government understands its limitations. Free markets tend to be thwarted where government can superimpose its will and where big corporate interests can get involved and manipulate the power of government to their advantage. And so this happens. This happens very often with federal regulations. One of the examples that I brought up in a Judiciary Committee hearing one time, I think it may have been the same hearing where we had a couple members of the Supreme Court testifying. I brought up a hypothetical example similar to my Commission on Good Laws theory a few minutes ago, where I said, imagine that Congress wanted to regulate dog breeding. You know, who would we turn to? Maybe we would end up handing over a fair amount of power to the American Kennel Club or something like that. When you put the task of establishing policy that's going to be binding on the entire country over to a few experts, those experts are going to have their own interests. And most of them, being fallible, mortal human beings, are going to find a way to develop that policy in a way that benefits them and their business interests. It's yet another reason why it's important for us to follow the structure in the Constitution. This is another one of those things that is not unique to one party or the other. We've got two political parties that are more or less equal opportunity offenders here. Both parties have participated in the distortion of these horizontal and vertical protections that we're talking about, and the crony capitalism that comes about as a result of this comes from both parties.
Do you think it's more of an issue for Congress or the executive? Or is it equal in both?
Well, the executive would never be doing all of the things that it is doing if Congress didn't voluntarily hand this over to the executive on a silver platter. So if I had to lay blame at the feet of one branch or the other, I'd put it on Congress. This is just what happens. I mean, this is, I've always been amused by a Far Side commercial that I saw many years ago, where this mother is opening the door to her son's bedroom, and her young son, maybe 7 or 8 years old, is in the corner cowering, and there are these hornets swarming around him. And she said, "Timmy, did you get out your hornet's nest again?" You know, and I always thought, it's kind of funny. It's just what happens. If you have a hornet's nest in a kid's room, sooner or later they're going to swarm. And so too here, when you allow power like this to be exercised by people who are not subject to elections, this is what happens.
Commerce Clause.
Oh, yes.
Is there anything that isn't justified by the Commerce Clause?
Oh, I thought you were going to ask if there's anything more fun to discuss in the Commerce Clause.
Is there?
No, not a chance.
Seriously, I mean, are there any limits on what Congress can do through ostensibly regulating interstate commerce right now?
Essentially, no. And I don't know whether you were finished with your question.
No, please.
Essentially, no. Since 1937, in a case that I talk about, decided on April 12th, 1937, NLRB versus Jones and Laughlin Steel. Since 1937, the Supreme Court has identified only 3 instances in which Congress has overstepped its limits under the Commerce Clause. The Commerce Clause, Article 1, Section 8, Clause 3, gives Congress the power to regulate commerce or trade between states, with foreign nations, and with Indian tribes. And since 1937, there have been only 3 instances where the court said it's overstepped its bounds. And since that same time period, the standard has been basically Congress may regulate not just interstate commercial transactions, a sale by someone in Utah of a product to someone living in Pennsylvania, for example, and not just channels and instrumentalities of interstate commerce. And by this I mean interstate airways, airwaves, waterways, roadways, and so forth. But also any and every activity that, when measured in the aggregate, when replicated across the various states, can be said to have a substantial effect on interstate commerce. Now, if you're not a lawyer, or if I just put you to sleep with that long phrase there, what that means is Congress can regulate anything. There's almost no human activity that cannot be regulated under that framework. The only real limit is Congress's ability to phrase it the right way so that it's tied in correctly. So the 3 exceptions that I'm referring to are, number 1, United States versus Lopez, decided by the Supreme Court in 1995, in which the Supreme Court said that it invalidated certain provisions of the Gun-Free School Zones Act. So bare non-commercial possession intrastate within a school zone of a gun, that's beyond the Commerce Clause. In 2000, United States versus Morrison, the Supreme Court invalidated certain provisions of the Violence Against Women Act based on the same grounds. In both cases, Congress basically got a little reckless and didn't connect the dots in the way it phrased the language there. They are more or less blips on the radar screen. 2012, NFIB versus Sebelius. The Supreme Court was addressing the question whether Congress overstepped its bounds under the Commerce Clause in adopting the individual mandate of Obamacare. The court there said, yeah, Congress overstepped its bounds because you're regulating inaction. You can't regulate inaction under the Commerce Clause. But even then, as I point out in the book, it didn't matter because the court kind of figured out a way to shoehorn this into a different freestanding power under the spending clause, under Congress's power to tax. They found this a valid exercise of Congress's power to tax. And so really there is essentially no limit. And the reason I discuss this in the chapter that is devoted to the 10th Amendment is that the 10th Amendment and Congress's enumerated powers, or the scope of them, they're 2 sides of the same coin. You can't really comprehend the 10th Amendment without understanding the extent of Congress's powers. And if any power of Congress, or all of Congress's powers lumped together, are without limit, then the 10th Amendment means exactly nothing. And because the Commerce Clause now gives Congress the power to regulate basically anything, there's almost nothing left for the states that is uniquely belonging to the states other than what Congress chooses not to regulate.
So who can fix this problem? Can Congress ever reform itself? And not just with respect to the Commerce Clause, but anything that you're talking about in the book. Who should we look for real reform? Is this something you think there's enough will within Congress to reform? Are you trying to get your colleagues to reform? Are you trying to get voters to become aware and outraged about these issues and hold their Congress people accountable? Are you looking to the court to fix this problem? It sounds like you don't think the executive will do much because any abuses in terms of the administrative state that they're involved in is just a function of Congress having given them these powers. So are you more optimistic about the courts or the people holding their Congress people accountable, or Congress somehow reforming itself?
This is and has to be an all of the above strategy. And I'm glad you asked that question because it's a central part of the book. I don't think we can rely on any one single branch of government to do it. I think it needs to involve all 3 branches. Now, the Supreme Court has basically always been involved in constitutional analysis, and this is a good thing. The bad thing is that too many of us in society, and way too many of us in Congress are inclined to think that the Constitution is a court thing, that when you bring up the Constitution, and I'm glad to have my National Constitution Center version of the Constitution here. I rotate copies, and now this has entered the rotation. It's a really nice-looking copy, by the way. That as soon as you start talking about the Constitution, too many in Congress think, well, that's a Supreme Court thing. Let's let them decide that. And here again, both parties have participated in this. One of the examples I point to in the book is an example of when a president from my party, not going to say who, his middle initial is W, signed into law a constitutionally problematic campaign finance reform. And while acknowledging the constitutionally problematic nature of some of these provisions, he said, oh, I'm going to sign it anyway, and we'll let the courts worry about the constitutional issues. I don't think that's okay. It's not acceptable. We have to expect more. We've been told that that's just how it operates, but it can't be anymore. We can't rely on the courts to fix every one of these defects, especially because, for reasons I explain in the book, the political branches, meaning the executive and legislative branches, have pushed a lot of this stuff onto the court, have intimidated the court into doing these things. NLRB versus Jones and Laughlin Steel, which we talked about a minute ago, was decided, not coincidentally, just a few weeks after FDR's court packing plan was announced. And so the political branches put the Supreme Court into this box. I think we're going to have the help of the political branches to pull us out of this constitutional box. And in order for that to happen, the voter, the everyday voter, Democrat, Republican, Independent, or whatever, will need to become more conversant in the Constitution and will need to expect more from his or her senators and congressmen on the Constitution.
So what you described there is certainly a serious problem, right? The Congress executive saying, there are constitutional issues here, but we'll leave that for someone else to work out. But let's imagine a case where Congress is very happy and confident with the constitutionality of a statute. The president is too, and the court eventually sees this, in a case and says, you guys are completely wrong. This is a horrible thing. They throw the whole thing out. Is that a problem, or is that exactly what's supposed to happen under a separation of powers?
That is what's supposed to happen under separation of powers. If it's unconstitutional, no matter how constitutional Congress and the president think it is, if it is in fact unconstitutional, the court has an obligation to invalidate it. And by the way, I may differ somewhat from some other self-styled conservatives in that there are a lot of conservatives who will harp all day long about judicial activism but say nothing about judicial passivism. I think they're both equally repugnant to the Constitution. In other words, it is no more defensible to uphold an unconstitutional law in court than it is to invalidate a law that is not unconstitutional. Both are equally bad. So I was going somewhere with that. I think I answered your question. But yeah.
It's fine for different branches to disagree about the Constitution. That is them exercising their duty to protect the Constitution.
Yeah, it's what
the problem is when they just pass it around each other, right?
Mm-hmm. Mm-hmm.
So we've had some questions come in from our audience here.
Great.
And we'll move on to a few of those. So 9 Supreme Court justices rarely agree on issues. Why should we expect Congress to be able to agree on these issues? And aren't they just sort of making practical decisions and agreements with each other, and legislation is always going to be messy and we just have to accept it, and that's maybe going to include some constitutional questions that have to be resolved by the court?
Yeah, look, that's a great question, and make no mistake, I operate under no delusion that all of a sudden if you have all 435 congressmen and all 100 senators reading and conversant in the Constitution, its text and its history, that they're all of a sudden going to agree as to the meaning of every provision. They're not. And yeah, we are called upon to make practical decisions, but one of those those decisions need to be framed by the boundaries outlined in the Constitution. The problem right now is not that we don't agree on the meaning of individual provisions of the Constitution. It's that most of them are almost deemed out of bounds within the framework of casting votes or marking up a particular bill in Congress. It needs to become part of the political dialogue and not just a dialogue that occurs in court.
So there's a question pointing to a paradox. If, as your book states, the court failed to enforce the Second Amendment for so long, why do we Americans own over 300 million firearms?
Well, the good news there was most states weren't doing quite what the District of Columbia was doing that gave rise to the Heller case. The District of Columbia had some of the most restrictive gun laws anywhere in the nation. And so notwithstanding the fact that there was some uncertainty about the Second Amendment, and that uncertainty allowed for some really nasty and I believe unconstitutional laws to come onto the books, as happened in D.C. There were lots of other parts of the country where there was still an acknowledgement of the fact that this is a pretty fundamental right, and where people weren't unreasonably hindered in their ability to exercise that right. And that's a good thing. It was interesting, though. I tell the story of this case that led many, incorrectly I believe, to start regarding the Second Amendment as dead letter law, or at least is not providing an individual right. I tell the story of that case, and it's quite fascinating. But it's a good thing that most of the people in the country acknowledged this right for what it was. They still acknowledged that they had a right to bear arms. And it was equally disappointing, as I point out in the book, that late Chief Justice Berger made a comment shortly after he left the court suggesting that the Second Amendment was something that everybody ought to just forget about because it didn't really do anything. That was disappointing. He was a good man, but that was a silly statement to make. And it turned out to be wrong.
So there's a question about the ACA and Chief Justice Roberts' decision, and whether that was within the constitutional power of the court to interpret the act in that manner.
No, absolutely not. I mean, I refer to that in my book. I describe it. In fact, I felt so strongly about that when I wrote an ebook about that. It's called Why John Roberts Was Wrong. I haven't been invited back to the Supreme Court Christmas party since then. I think that was one of the most grave miscarriages of justice in modern history. Because look, regardless of where you stand on the Affordable Care Act, regardless of whether you think it's good, sound legislation, it was the decision rendered by the court and the course charted by the Chief Justice to make that constitutional entailed the Chief Justice and the 4 justices who joined with him in that opinion to essentially rewrite the Affordable Care Act, not just once but twice. That is a power the court does not have. Now, there are people out there who want to defend that, who will go out of their way to say, well, yes, but he was trying to protect the legitimacy of the court. He was wanting to make the court not appear overly political. Well, if that's the case, then he shouldn't have done this. It is Congress that passes the law. It is Congress that needs to amend a law, and the court doesn't have the power to rewrite a law just in order to sustain it. What he did was without precedent. What he did was without support in the text of the statute, and what he did was utterly incompatible with the Constitution and with his judicial oath. Other than that, I don't really have any opinion about it.
So another question that invokes as an example of the ACA, And it's a question that surely you face as a politician, but I think all of us face, regardless of what side we're on of particular issues. The example is, if you don't like Obamacare, then you're against all forms of social assistance, and these sort of very heated allegations that I think we've all had exchanges in the last few years with friends. A lot of people think politics has never been this divisive. I'm not sure. If you read some of the stuff that went on in the 18th and 19th century, it might
I've never seen anybody
but
getting beaten to death with a cane
exactly.
in the Senate. You know?
But how are we supposed to respond to these sorts of like visceral disagreements over political issues, and how much of the heated disagreement today is a function of what your subtitle describes as the willful subversion of these basic constitutional principles? If we adhered to them more, would we have these same sorts of divisions?
If we adhered to them more, we would still have some of the same divisions. But I believe some of the roughest edges of those divisions would be taken away. Let me explain what I mean. There's a part in the book where I explained that when we respect the vertical and the horizontal protections, we respect federalism and separation of powers, it takes away some of the acrimony from government. In other words, there are a lot of regional differences throughout the country, a lot of differences that may vary from one state to another in terms of the kind of government people want, in terms of the way people think about government in general. One example that I point to is that in Vermont, as I describe in the book, there are a lot of people there who would very much like to see a single-payer, government-run, government-funded healthcare system. I think there is polling suggesting that more than any other place in the country, there's very strong, a very strong opinion on that in Vermont. People in my state, Utah, are less likely to want that. The people in Vermont ought to have the ability to do that without undue interference from the federal government. It's actually made harder that so many of these decisions are made at the national level. It's harder for people in states like Vermont to set up a system like that because they can't set it up, they can't control it the way they want to, because so many of our tax dollars, between 20 and 25 cents out of every dollar that moves through the American economy in one way or another ends up going through the federal government. If we respected federalism and separation of powers to a greater degree, sure, we'd have some of the same disagreements about what the purpose of government is, about what government ought to be doing in the abstract. But I think you would see a lot more people in America getting more of the government they want and less of the government they don't want if more decisions could be made at more of a local level. And by the same token, I think if we followed separation of powers, we'd see a corresponding set of benefits that would come along and some less acrimony. I do want to add one other thought to this. The degree of acrimony, it's not just that there were bad things that happened in the olden days too. They fought, people beat each other with canes, which I've never seen happen, fortunately, since I've been in the Senate over the last 4.5 years. It's not just that, but there really is a good sense of collegiality in Congress today. I mean, I really like a lot of my Democratic colleagues. I have great conversations with them. We even agree on a lot of issues. That stuff doesn't ever get reported. I think most people in this room might well be surprised to see how well we actually get along on a lot of things. There are some issues on which we're never going to agree, but that again gets back to regional differences. That again gets back to the fact that Americans in different parts of the country have a different vision for what government ought to be, and I think federalism was meant to accommodate that.
If we had a really robust federalism today, especially considering technology, people working from home, all sorts of different things, do you think we would have a radically different nation? That more and more people would be looking at the bundle of rights and protections that states give and say, Utah looks pretty good to me. It's not perfect, but I want to move there. Do you think we'd see a lot more mobility, or would people still be frustrated because I'm a Pennsylvanian, I'm not moving, I'm from Tennessee, I'm not moving? Do you really think it would affect individuals in the way?
Yes. Yes, I do. I do. I think you'd probably end up seeing more mobility. We do have a very mobile society today, more than I think at any other time in our history, and that's a good thing. People will move from state to state as they have better job opportunities or as they see one reason or another to move to another part of the country. Make no mistake, I'm not trying to outline a teary-eyed utopian vision for what would happen. I'm not saying that if we followed federalism more faithfully, all of a sudden you'd have all the children throughout the world holding hands and singing a song. But it would be better. I do think there are substantial benefits that would be achieved through that. The biggest reason for that has to do with the fact that you would have states operating as they were intended by the founding generation. The founders sometimes would refer to the states as laboratories of Republican democracy. Things could be tested and tried in one state and then another. And when certain policies worked really well in Texas, they could be emulated in Massachusetts or the other way around. Some of that happens now. There's a fair amount of that, but there would be a lot more of it if we were really living under federalism. And I think people would see the benefits that can come from a less intrusive government more clearly that way.
One final audience question. I will frame it more broadly, prompted by this question, and it just invite you to give us your thoughts on the Fourth Amendment, which you discuss in the book. And then I'll invite you, but not compel you, to ask the very specific question our audience member asked. How do you intend to vote on Section 215 of the Patriot Act coming up for renewal June 1st? Does it conflict with unreasonable search guaranteed in the Constitution?
I intend to vote no. I intend to vote no on 215 renewal. That is, absent some very significant structural reform to the way it's written. And I'm sorry, I'm not sure if you were finished asking your question. Yeah. And I explain this in the book. I explain a lot of my reasons for my concerns about Section 215 of the Patriot Act. I do so by telling a story. One of my favorite stories in the book is actually found in this chapter that discusses Section 215. It's a story of a guy named John Wilkes, not to be confused with John Wilkes Booth, the assassin of Abraham Lincoln, but John Wilkes, the English parliamentarian who served during the reign of King George III. Now, there were these weekly circulars back in those days in England, and they would discuss the political issues of the day. A lot of them were very favorable to the king, and they would applaud the king and the great things he was doing. But John Wilkes ran a circular that was not exactly in that mold. It was called the North Briton, and he sometimes would criticize the king, not just the king's ministers, but sometimes the king himself, based on policies that he found upsetting. And as he did this, he started to attract some attention. The straw that broke the camel's back as far as the patience of King George III was concerned was a circular called North Briton number 45. These were numbered weekly circulars, sort of like the Federalist Papers. North Briton number 45 really made King George III mad. And it ended up culminating in the arrest of John Wilkes. He served some time in jail. He had his home and his papers searched and seized, and he was subject to a general warrant that didn't adequately outline the nature of the things to be searched. And this North Briton number 45 became famous, not just in Great Britain, but also in America. And so on both sides of the Atlantic, the number 45 became synonymous with the quest for liberty. People wrote the number 45 on the side of taverns and saloons. People would celebrate by buying drinks for 45 of their friends, which they would drink while eating 45 ham sandwiches. So the number 45 became quite significant. I had this really neat moment this morning when I checked on the status of my book. I checked on, there's this thing on Amazon where you can check to see how whether anybody's interested in your book. And my book was ranked number 45 on Amazon's list. And I thought, this is Providence smiling upon me. Anyway, my point is, the founding generation was inspired by John Wilkes and by his writings about the sanctity of privacy, the sanctity of one's home and one's papers and one's person, that they shouldn't be subject to an unreasonable, open-ended search or seizure. That's what got us the Fourth Amendment. And it's that very same complaint against general warrants, against these sort of roving fishing expedition type open-ended search warrants, that causes me grave concern about Section 215 of the Patriot Act and the manner in which it's been interpreted and implemented. I find it concerning that everyone, not just in this room, but in this country, who has one of these, and I'm not referring to this particular model of telephone, but everyone who has a phone has records being made by the NSA of everyone who has called you and everyone you have called, the timing of that call, the duration of the call, going back 5 years. That can all be searched and analyzed. That can tell all kinds of things about you, not just your age and your gender, but your religious affiliation, your political affiliation, where exactly you fall on the political spectrum, the condition of your health, what specific ailments you might suffer from. I mean, there are algorithms that have been developed by researchers outside of government trying to replicate what government could do with this. You couple that with something else I discuss in the book, the Frank Church Report, remember, from the late 1970s, which talked about the fact that every presidential administration from FDR through Nixon, Republican and Democratic alike, used our nation's intelligence gathering infrastructure as a means of engaging in political espionage. We've seen this movie before. We know how it ends. We need to be very, very careful about how these powers are exercised. And the Fourth Amendment provides us with more than enough reason to be careful about Section 215 of the Patriot Act.
I'm sorry we couldn't get to all of the excellent questions from the audience, but thank you to everyone who did submit something. Thank you for coming. We have copies of the book available for sale and signature, I think.
Absolutely.
And thanks, of course, to Senator Lee for coming out tonight.
Thank you.
Senator Lee.
Thank you very much.
It's fun.
Doesn't Congress have